back to my channel and welcome to Persons and Family Relations. Today we will discuss Articles 3 and 4 of the new Civil Code. If you have not yet seen our previous videos, I suggest that you go on to the description button below and hit the link so that you will be updated of our first and second video in Persons and Family Relations. We are now in Article 3 of the new Civil Code, which provides that ignorance of the law excuses no one from compliance therewith. This is actually more popularly known as the Latin maxim, ignorantia lihes non excusat. We talked about the publication requirement last time, and we said that it is required to satisfy the due process requirement. Bakit ba? Nga naman, why? Kasi when the law is published and becomes effective, it is conclusively presumed that everyone knows about it and is bound to obey it. Now the question is, what is the extent of applicability of the maxim? It actually extends, ladies and gentlemen, to all kinds of domestic laws, whether civil or penal, whether substantive or remedial. Now, when we say civil, this is actually a branch of law that generally treats of the personal and family relations of an individual, his property and successional rights, and the effects of his obligations. Ang example ani kaning atong subject. When we say penal, this is that branch of law that defines crimes, treats of their nature, and provides of its penalties. Substantive, on one hand, is that which establishes rights and duties. Remedial is that which prescribes the manner of enforcing legal rights and claim. Again, the maxim on ignorance of the law will only be applicable to our laws, okay, to our domestic laws, which means that ignorance of foreign laws is not ignorance of law, but mere ignorance of fact, and must be alleged and proved. So, kailangan pag nag-raise ka ng foreign law, kailangan mong i-allege muna at i-prove para tanggapin ng ating courts as a matter of fact. Okay? Yung example lang naman nito, yung marriage celebrated in China before a village leader doon sa China. Now, itong marriage nito cannot be recognized as valid here in the Philippines unless magpapakita ka ng proof that indeed in China and according to Chinese law, itong marriage na ito is regarded as valid. Without such proof, we will presume that the marriage or the law on marriage in China is the same as the law in the Philippines. And in our country, we have to note that a village leader cannot actually perform a marriage. So we call this presumption as processual presumption. The doctrine of processual presumption states that the foreign law, whenever applicable, should be proved by the proponent thereof. Otherwise, such law shall be presumed to be exactly the same as the law of the forum. This doctrine, ladies and gentlemen, was mentioned in the case of Collector of Internal Revenue versus Fisher, decided in January 28, 1961. Ano bang nangyari dito? Ang facts ng case na ito are as follows. Si Walter Stevenson was actually born in the Philippines of British parents and married in Manila to another British subject, Beatrice. So, mag-asawa itong si Walter at si Beatrice. Si Walter actually died in 1951 in California, where he and his wife Beatrice moved to. Sa will ni Walter, he instituted Beatrice as his sole heiress to certain real and personal properties dito sa Pilipinas. And among dito sa property na ito are actually 210,000 shares of stocks in Mindanao Mother Lode Mines. Okay? Tapos, si Ian Morey Stat was actually the appointed ancillary administrator of the estate. Itong si Stat actually filed an estate and inheritance tax return on behalf of the estate of Walter. He then made a preliminary return to secure the waiver of the CIR on the inheritance of the mine shares of stock. And tapos noong 1952, si Beatriz assigned all her rights and interest in the estate of the spouses Fisher. Itong respondent sa case na ito. Tapos, in September 7, 1953, itong administrator na si Stat actually filed a second amended estate and tax return on behalf of the estate of Walter. The tax return, declared the same assets of Walter. Okay? Except that, may panibagong claims na naka-include doon sa second return niya. Among the claims are the additional exemption and deduction as follows. Una, deduction in the amount of 4,000 pesos from the gross estate of the decedent as provided for, according to him, in Section 861 of the U.S. Federal Internal Revenue Code, which, according to Stat, was allowable dito sa Pilipinas by virtue of the reciprocity agreement as provided for in the National Internal Revenue Code. Yung pangalawa, yung exemption from the imposition of estate tax and inheritance tax on the 210,000 shares of stocks in the Mindanao Mother Lode Mines, Inc. Also, according to him, pursuant to the reciprocity proviso in the National Internal Revenue Code. In this return, itong final ni Stat na return, the estate actually claimed that it was only liable for 525.34 pesos as estate tax and 238 pesos for inheritance tax. And that, as a consequence, sabi ni Stat, nag-overpay sila ng bayad sa gobyerno. So dahil nag-overpay sila sa pagbayad sa gobyerno ng kanilang taxes, sabi ni Stat, we are entitled to a refund of what we paid in the amount of 15,259.83 pesos. Okay? Ang collector naman ng CIR actually denied the claim, and for this reason, an action was commenced in the Court of First Instance, now the Regional Trial Court of Manila, by the respondents Fishers, as assignees of Beatriz Mauricia Stevenson for the recovery of the 15,259 pesos 0.83 centavos. Now, the issue here is this: whether or not in determining the taxable net estate of the decedent, one half of the net estate should be deducted therefrom as the share of the surviving spouse in accordance with our law on conjugal partnership and in relation to the National Revenue Code? Or do we follow the law cited by the administrator Stat in this instance? So how did the Supreme Court rule in this case? According to the Supreme Court, in deciding the issue, the lower court applied a well-known doctrine in our civil law that in the absence of any antenuptial agreement, the contracting parties are presumed to have adopted the system of conjugal partnership as to the properties acquired during their marriage. The application of this doctrine to the instant case is being disputed, however, by petitioner collector of internal revenue who contends that pursuant to Article 124 of the new Civil Code, the property relation of the spouses Stevenson ought not to be determined by the Philippine law but by the national law of the decedent husband, and in this case, the law of England. It is alleged by the Collector of Internal Revenue that English laws do not recognize legal partnership between spouses, and that what obtains in that jurisdiction is another regime of property relations wherein all properties acquired during the marriage pertain and belong exclusively to the husband. And to further support his stand, he cited Article 16 of the new Civil Code to the effect that intestate and intestate succession kuno, the amount of successional rights among others is to be determined by the national law of the decedent. Pero, ang Supreme Court relied on the opinion of Manresa and they cited as follows. Sabi ng Supreme Court, according to Manresa, the law determinative of property relation of Stevenson's married in 1909 would be the English law even if the marriage was celebrated in the Philippines, both of them being foreigners. But, ningon ng Supreme Court, sabi ng Supreme Court, as correctly observed by the tax court, the pertinent English law that allegedly vests in the decedent husband full ownership of the properties acquired during the marriage has not been proven by the petitioner. Except for a mere allegation in his answer, which is not sufficient, according to the Supreme Court, the record is bereft of any evidence as to what English law says on the matter. And in the absence of proof, the court is justified, therefore, in indulging in what Wharton actually calls as the processual presumption, in presuming that the law of England on this matter is the same as our law. So therefore, the Supreme Court in this case finds that the lower court correctly deducted the half of the conjugal property in determining the hereditary estate left by the deceased Stevenson. Okay. We now go to Article 4 of the new Civil Code, which provides that laws shall have no retroactive effect unless the contrary is provided. In general, we have to remember that laws are prospective, not retroactive. Okay? While the judge looks backward, the legislature must look forward. Pasabot, ibig sabihin, the law should always look forward and never backward. If the rule was that laws were retroactive, grave injustice would occur, for these laws would punish individuals for violation of law not yet enacted. And we have to remember that while ignorance of the law does not serve as an excuse, such ignorance refers only to laws that have already been enacted. Okay? Simply stated, when a law is passed increasing the tax brackets for good-looking individuals to be effective on October 20, 2020, the said law cannot impose a higher tax bracket before October 20, 2020 because this will look forward and not backward. Pero, isa ito sa dapat nating i-remember na every rule has an exception. Para lang yung boyfriend mo pag nagkasala, ang general rule, pag nagsorry yan, patawarin mo, di ba? Pero pag ang kasalanan ay talagang grave na, like cheating for instance, ang general rule hindi na yan mag-a-apply. We go now to the exception, which is hiwalayan mo na. Unless of course martir ka o sadista na okay lang sa'yo na masaktan. 'Di ba? Pero ganyan din naman ang batas. May general rule tayo. And in Article 4, ang general rule natin ay ang rule na laws are prospective. Pero may mga exceptions na ang law, pwede na ang application ay retroactive. What are the exceptions? Ang first, if the law provides for retroactivity. Second, when the statute is penal in nature, provided it is favorable to the accused or the convict, and provided further that the accused or convict is not a habitual delinquent. Second, if the laws are remedial in nature. And lastly, is if the law is curative. Now we go to the first exception. The first exception is if the law provides for retroactivity. If ang batas na mismo ang nagsabi na ito ay mag-a-apply retroactively, then we must apply the said law retroactively. Example, when a law is passed condoning the payment of taxes from October 20, 2019 to October 20, 2020, effective October 20, 2020. So, those who failed to pay the taxes from October 20, 2019 to the law's date of effectivity will be condoned since the law actually provides for its retroactive application. Now, This exception also has another exception. It provides that even if the law provides for retroactivity, no retroactive application can be made if the law will become an ex post facto law. When we say ex post facto law, it is one that makes criminal and punishable an act done before the passing of the law and which was innocent when done. Example, kung ang Congress magpapasa ng law na ipipinalize yung mag-unmute ng mga microphones nila during online classes when the professor is speaking, and the law is passed in say October 20, 2020. Tapos ikaw pag September 28, 2020 during your online classes, nag-unmute ka ng iyong microphone at narinig namin yung mga nagbabark mo ng mga dogs at nagtitilaok ng mga manok, diba? The question would be, can you be penalized on October 20, 2020 for what you have done in September 28, 2020? The answer is no. Because if we apply the law retroactively, the same will become an ex post facto law. Walang problema kung ang application is October 20, 2020 onwards. Pero, pag ipapunish ka for what you have done in September 28, 2020, in fact, hindi pa naman crime pag nag-unmute ka noong panahon na iyon, hindi na yan pwede. Kasi, the said law will be considered as an ex post facto law. And this is an express prohibition under our Constitution, which provides that a law that makes criminal and punishable an act done before the passing of the law and which was innocent when done is not allowed under the Constitution. Another kind of an ex post facto law is that one that decreases the quantum of proof for conviction. Ang example nito ay yung crimes, okay? Let's say, in a crime of adultery. In your study of criminal law, you will learn that before a person can be convicted of a crime, kailangan munang i-satisfy ng state ang elements constituting the crime. If say, a crime of adultery, to successfully prosecute the crime of adultery, you need to prove the following elements. First, that the woman is married. Second, that she has sexual intercourse with a man, not her husband. And second, that as regards the man with whom she has sexual intercourse, she must know her to be married. Tapos suppose a law is passed removing the third element, and the law is to take effect in October 20, 2020. Wala itong problema as long as it is not to be given a retroactive effect. You will have an exhaustive discussion on this concept in your criminal law and consti, I believe. Another exception to the prospective application of law is when the statute is penal in nature, provided that it is favorable to the accused or the convict, and provided further that the accused or convict is not a habitual delinquent. An example of this one is the case of People versus Sinosa, which you will see in the following video. Hi guys, welcome back to my channel. Today we will discuss the case of People versus Sinosa. This case actually led to the development of RA 9262 or VAUSE and released women suffering from battered woman syndrome from criminal liability in case they commit a crime against their spouse or partners. Ug karon atong mahibaw-an kung unsa na ang battered woman syndrome ug kung magamit ba ni siya nga depensa kung naa kay makommit nga crime against sa imuhang partner or imuhang spouse as the case may be. So, mag-start na ta sa pag-discuss sa facts sa case sa People versus Sinosa. And of course, as usual, we will start with the parties of the case. Ang parties here are Marivic and Ben, okay? Marivic is the wife, Ben is the husband. So, unsa may nahitabo diri, no? Si Marivic is actually married to Ben, and during pa sa first year sa ilahang marriage, they were actually happy like other couples, no? And then kinadugayan na nga nag-ipon sila, mag-away sila, and kani nga fights would sometimes or would oftentimes lead to violence. Kani magud si Ben is actually palahubog. He's a drunkard. And every time masuko siya or mag-away sila ni Marivic, iyang kulatahon si Marivic. And every time kulataho niya si Marivic, muli si Marivic sa ilaha. Uli ni Marivic sa ilaha, apason siya ni Ben. So in town si Marivic hoping nga maokey ra tanan kay giapas man siya ni Ben, muli sa siya dito sa ilaha. But kani siya permining nahitabo. Muli si Ben hubog, kulatahon siya, mulaya si Marivic, suyuon na sad niya si Marivic ni Ben, and then mubalik na pud si Marivic. This happened for the longest time sa ilahang marriage until one night si Marivic nga 8 months pregnant napuno na. Ug sinhitabo dire si Ben gikulata siya. Apan si Marivic nakadagan siya sa pikas kwarto dito sa kwarto sa ilahang mga anak. And human dito nagpabugnaw sa siya, and then tungod kay nahadlok man siya sa iyahang bana nga pasakitan na sad siya, unya basig makuhaan sad siya since 8 months pregnant siya, gipatay ni Marivic ang iyahang bana nga natug. Gisod niya dito sa kwarto nga natug ug iyang gipusil. Naturally, gikiha siya sa family ni Ben og parricide, and she was actually convicted. Unya niabot ning kasuha ngadto sa Supreme Court ug niingon si Marivic nga, I am actually justified in killing my husband because I am suffering from battered woman syndrome. And me being suffering from battered woman syndrome, that should constitute as a self-defense. O kung self-defense na siya, Your Honor, I should not incur any criminal liability since justified ko in killing my husband. So, abot ni sa Supreme Court, and ang issue dito nga niabot sa Supreme Court mao ni whether or not si Marivic can validly invoke battered woman syndrome as constituting self-defense. So, atong tanawon kung giunsa ni pag-decide sa Supreme Court. Pero ato sa din tanaw no kung kanusa man ka makaingon nga ang babae is actually a battered woman. Tanawon kuno nato giunsa ni pag-storya or pag-desider sa Supreme Court. Niyon ang Supreme Court, a battered woman has been defined as a woman who is repeatedly subjected to any forceful physical or psychological behavior by a man in order to coerce her to do something he wants her to do without concern of her rights. Battered women include wives or women in any form of intimate relationship with men. Furthermore, in order to be classified as a battered woman, the couple must go through the battering cycle at least twice. If it occurs a second time and she remains in the situation, she is defined as a battered woman. Kung sa maning kaha ang mga personality traits nga gipakita or gi-exhibit sa mga battered women. Ningon ng Supreme Court, battered women exhibit common personality traits such as low self-esteem, traditional beliefs about the home, the family and the family sex role, emotional dependence upon the dominant male, the tendency to accept responsibility for the batterer's action, and the false hopes that the relationship will improve. Sadly, no, ang battered women, ang ilahang self-esteem is very low. Unya, ilahag yung pagtuo nga ang babay is of lesser role ikumpara sa usa ka lalaki. Unya, kung kasagaran masuko ang lalaki or kung masuko ang mangulata sa ilaha, feeling nila gikulata sila because sila'y sad-an. Mao kuno na ang common traits nga gi-exhibit sa usa ka battered woman. And more graphically, ningon ng Supreme Court, the battered woman syndrome is characterized by the so-called cycle of violence, which has 3 phases. So, naay cycle of violence, ningon ng Supreme Court. Unsa ka ni nga mga 3 phases sa cycle of violence? Ang una, the tension-building phase. Ikaduha, the acute battering incident. O ang ikatulo, the tranquil, loving, or at least the non-violent phase. Karon, sa desisyon sa Supreme Court, iyahag yun nga gi-illustrate kung kanus-an na ay tension-building phase, kanus-an na ay acute battering incident, o kanus-an na ay tranquil, loving phase. The Supreme Court said, during the tension-building phase, minor battering occurs. It could be a verbal or slight physical abuse or another form of hostile behavior. So dire, nang init na ang ulo sa mangulatahay. Okay? So, unya, diresad ang babay, ang battered woman, iyang itry nga ipacify ang kalagot sa iyang batterer. Unya, ang ikaduha nga phase sa cycle of violence, ang acute battering incident. Here, kaning incident is characterized by brutality, destructiveness, and sometimes, sadly, death. So, diri na gyud mangulata pag-ayo ang batterer. Unya, ang babay, dinhi iya na pong ma-realize, or ang battered woman dinhi niya ma-realize nga wa na gid siya mahimo para mapugnan ang batterer. And in fact, wala na lang siya buhaton, kundi pasagdan na lang si batterer nga gikulata siya. And the final phase here is the tranquil period. The couple here experience a profound relief. Sa lain nga bahin, the batterer may show a tender and nurturing behavior towards his partner. So ang nangulata diri sa tranquil loving phase, iyan ang labing-labingon ang iyahang asawa or ang iyang uyab baron or ang iyahang partner, as the case may be. Unya, si battered woman sad nga gikulata, feeling sad niya, iya pong sa nganong gikulata siya. Unya, in this case, kay gilabing-labing naman siya, ang iya pong pagtuo nga mausab pa ang batterer. Unya, iyahan na lang pasayloon in this phase. Pero enough ba ni nga mga cycle aron mapatay ni Marivic si Ben? Ningon ng Supreme Court, in any event, the existence of the syndrome in a relationship does not in itself establish the legal right of a woman to kill her abusive partner. Evidence must still be considered in the context of self-defense. In fact, ningon ng Supreme Court nga settled is our jurisprudence, however, is the rule that one who resorts to self-defense must face a real threat on one's life, and the peril sought to be avoided must be imminent and actual, not merely imaginary. And giklaro sa Supreme Court nga ang unlawful aggression is the most essential element of self-defense. It presupposes actual, sudden, and unexpected attack or an imminent danger thereof on the life or safety of a person. And then the Supreme Court said nga in the present case, however, according to the testimony of Marivic herself, there was a sufficient time interval between the unlawful aggression of Ben and her fatal attack upon him. She had already been able to withdraw from his violent behavior and escape to their children's room. And during that time, he apparently ceased his attack and went to bed. The reality or even the imminence of a danger he posed had already ended altogether, and he was no longer in a position that presented an actual threat on her life or safety. And as a conclusion, in the Supreme Court, we reiterate the principle that aggression, if not continuous, does not warrant self-defense. In the absence of such aggression, there can be no self-defense, complete or incomplete, on the part of the victim. Therefore, in the Supreme Court, Marivic's killing of Ben was not completely justified under the circumstances. So mo to guys, ang People versus Sinosa, it is worth noting no nga despite the affirmation of the Supreme Court on the conviction of Marivic in this case, kani pong kasuha actually led to the development of RA 9262 or Anti-Violence Against Women and Children Act of 2004.
Nga nag-ingon nga if a woman kills her husband or a partner, as the case may be, she will be excused from criminal liability.
So in this case, since self-defense naman yung battered woman syndrome and this is favorable to the accused, it can be given a retroactive application. Exception lang naman sa rule na ito is when the accused is a habitual delinquent. When you say habitual delinquent under the revised penal code, a person shall be deemed to be habitually delinquent if within a period of 10 years from the date of his release or last conviction of a crime of robbery, theft, estafa, or falsification, he is found guilty of any of the said crimes a third time or oftener. And you will have an exhaustive and extensive discussion on this one in your Criminal Law 1 and two subjects. Now, another exception to the rule that law shall have prospective application is when the laws are remedial in nature. Ang reason nito is that there are no vested rights in rules of procedure. According to the Supreme Court, remedial statute or statutes relating to remedies or modes of procedure which do not create new or take away vested rights but only operate in furtherance of the remedy or confirmation of rights already existing do not come within the legal conception of a retroactive law or the general rule against retroactive operation of statutes. And the last exception is if the law is curative. It is necessarily retroactive for the precise purpose that it is actually to cure errors or irregularities. So that's another asynchronous material for my persons and family relations this semester. Again, if you have not yet subscribed to my channel, please subscribe to my channel, Darchi Wagas, and hit that notification button so that you will be notified of my future videos. Again, I'd like to remind my students that if you have not yet seen our previous discussions, you may run through them in the description box. I dropped the link over there and you can just review it by clicking the links in the description bar. Thank you very much. Amping.